Welcome to the session on Unpacking Non-Personal Data presented to you by the Quantum Hub in association with ThePrint and Network Capital. Now, as India looks to march towards becoming a $1 trillion digital economy by 2025, regulation of data is at the top of the policy priority of this government. To this end, it has made many progressive moves, including the Personal Data Protection Bill that it introduced in Parliament, and a report on on the governance of non-personal data that it recently introduced. This policy proposal is beset with key economic, technical, and legal questions, which we shall be discussing today and over the next 2 days in 3 different online discussions. Specifically today, we are going to discuss the definition of non-personal data and how that plays into the regulation of data in general. To discuss these issues with us today, we have 4 experts on data governance. Firstly, we have Ms. Neha Chaudhary, who is a partner at Ikigai Law, a technology and innovation-focused law and policy firm. Thanks, Neha, for being with us. Then we have Ms. Riddhi Verma, who's a technology policy wing research fellow at the Technology Policy Wing at the National Institute of Public Finance and Policy in New Delhi. Next, we have Ms. Anubhati Singh, who's a policy analyst with the Future of Finance Initiative at Dwara Research. And last but not least, we have Ms. Smita Krishna Prasad, who is the director at the Center of Communication Governance at the National Law University, Delhi. Now, before we start, I'd like to explain the format that we're going to follow. We will have 45 minutes of discussion between the panelists and myself. And then we'll open up for questions, which can be asked through the YouTube chat function. We hope to take as many questions as possible in a 30-minute time frame. Right. Now, starting off, what is non-personal data? Now, the PDP bill, as well as the report of the Committee of Experts on Non-Personal Data, has defined non-personal data as any data that is non-personal. So what does this mean? This essentially means that any data which has no personal identifiable information, any personal data which has been anonymized will count as non-personal data. Now, obviously, this is a large set which has a huge ambit under it, which has various different legal and technical implications. So to start us off, I would request Smita to take us through maybe some of the legal implications of such a wide ambit of non-personal data. Smita.
Thanks, ThePrint. Thanks for organizing this and having me here. So like you mentioned, I think the definition of non-personal data is quite broad in the sense that it's just anything that's not personal data, as far as both the Personal Data Protection Bill that's before Parliament, as well as this report on non-personal data, on the governance of non-personal data that's just been introduced for consultation is concerned, right? And this is really a very, very wide bucket that could involve several different things. And the committee has also identified that one of the interesting things that it could involve is also anonymized personal data. And that's, it's something that's been discussed widely, even in the context of the Personal Data Protection Bill, because anonymization is not really, it's questionable whether that's a hard and fast rule in terms of what kind of standards we'd apply and whether it's truly anonymized and truly non-personal in that sense, right? So like I said, it's very wide, and I think one of the concerns is that there are so many different things that you can do with non-personal data. There are so many different things that the committee is proposing that the government does with non-personal data in terms of requiring sharing of non-personal data by private entities, especially with government as well as with other private entities in the country. And there's this idea that there's an intrinsic value to data and that we can all benefit from it in this country as a whole, whether it's the government benefiting from it, whether it's the private sector benefiting from it, or whether it's us as individuals getting benefits from the kind of use of data by the government as well as the private sector. So it's while we talk about this extremely wide category, I think the report itself tries to break this concept down because they understand as well that it's super wide, and they try and help break down the definition in order to describe data sharing as it would apply to each subset of non-personal data specifically. And so, for instance, the committee starts by identifying two different concepts of non-personal data. One is data that's derived from personal data or anonymized, so anonymized personal data or any sort of human-related data that could have a personal data element to it or could have had that in the past. And then they also talk about completely non-human related data, which could be things like the weather report and things like that, which don't really have a human element there. Then they also go on to talk about the different sources of data in the context of government and private sector data. And then they look at also this third concept called community data, where they're saying that data can arise from a specific community or group of people. And there's different aspects here that they have defined. But there's definitely a lot of overlaps in these kind of concepts that do exist as well, even though there is an attempt to break this down. I think the report tries to overcome some of these definitional challenges in some ways. First, they attribute sensitivity to non-personal data. They borrow from the concepts in the personal data bill, where they say that there's just general personal data, and then there's sensitive personal data, and there's critical personal data. And they try and similarly, cut across similar lines for non-personal data as well. But again, it's not foolproof clearly in this report, at least. I don't know if it can be if there are further iterations of this, because on the one hand, sensitivity is attributed in the context of non-personal data that's derived from personal data, but on the other hand, the sensitivity is also attributed in the context of, say, sensitivity in terms of security of the state and national security reasons and things like that. The other way in which I think the report tries to overcome some of the challenges is by looking at this idea of beneficial ownership, especially in the context of community data or data that's derived from personal data. But again, that's still also that concept as well comes with its own challenges. So I think that's broadly the answer would be that yes, it is a very wide, very very wide bucket of data that falls under non-personal data, and there are some attempts to cater to that or to solve for that problem. But I think it raises a lot of questions as well that we can probably discuss over the rest of this session.
Thank you, Smita, for that very cogent explanation of how wide the ambit is. That was maybe the legal perspective. In terms of maybe the technical perspective, we see that non-personal data includes anonymized data. And there have been a lot of articles and reports saying that no data is really truly anonymized, and de-anonymization is possible with most types of data. So Anubhuti, if you can maybe take us through what level of anonymization is required to truly call data non-personal, and how big an issue is de-anonymization?
Sure. So I think one of the crucial concerns that we face with this report regarding any data that's not personal data as per the PDP bill to be non-personal data, which can then be regulated as per these as per the guidelines of the draft framework. And as Smita correctly said, any data that is not personal data and does not have any personal identifiers would then comprise of non-personal data. And then again, as she said, there is a human aspect and a non-human aspect. So even if we just broadly spoke about data, there would be data that is not coming from humans at all. So this is literally coming from satellites, from sensors, from machines, from which are probably gauging climates, temperatures, machine behavior, supply chains. So here, I mean, in some sense, we could regard this purely as non-personal data because there is no scope of personal identifiers here. The problem really comes when we talk about human-related data, and obviously there is lots of it. Every individual on this planet is generating huge amounts of data trails every moment of their life, every time they interact with somebody, every time they window shop, every time they browse on the internet. And A, all of this data is very large in volume, and B, it is by nature connected, like fundamentally related to a human. So when we talk about anonymization is really the technique by which you, where you treat data or databases in a manner that any personal identifiers are no longer present in that particular data set. And often in a lot of privacy and data protection literature and a lot of technical literature about privacy enhancing techniques, we discuss anonymization a lot. The key problem is, and as Smita very clearly mentioned and is well known, is that anonymization, unfortunately, is not irreversible. The desire and the ideal condition would be for anonymization to be irreversible, which is also a standard that the Personal Data Protection Bill talks about, for instance. But we have a lot of research to say, a lot of computer science literature to say that anonymization cannot be irreversible, at least not at this stage. It is obviously the computer science ideal for it to be irreversible, but at this point, it's not possible. And I think if you had to really get down to the nitty-gritties of it, a lot of literature finds that where you have large aggregated data sets, where the dimensions of the data set are very large. So I think here I'll talk about the rows and columns. So if you've got a very large data set and you've got a very high sample, which means that the number of people you have data on is super large, and therefore you have a lot of rows. And the dimensions of that particular data is very high. So for every given individual, you have a lot of data points. So for instance, for me, you have everything from a demographic information all the way till what my web search history was about 5 years ago. And that's a lot of dimensions to have for one particular sample within the data set. Research has shown that when there is high dimensionality and when there is high volume of data, almost there's a very high chance that you would be able to track back their data to the individuals. And even if we didn't want to make such an assertive statement so as to say that you can granularly track down which person the data belong to, you can still identify communities, you can still identify groups within that data set that have discernible qualities, which unfortunately does relate to communities. And therefore, it can be acted upon. So whether that causes collective harm, whether that causes targeted advertising that leads to unfortunate consequences, we can't say. And now this was only the case for static databases, wherein we're saying that there is a database which is just present and people have access to it. More practically, and for something like this, something that the draft framework is suggesting, which would really be building an ecosystem with several entities, where you're mandating different entities to be sharing data, building architectures, building data pipes for them to be sharing data. It is probably safe to assume that all of this data might be hosted on cloud servers, or they might be hosted on some kind of servers where entities based on their access controls or their restrictions to that kind of data are accessing it on a query basis. So they might not have the whole data set, but they might still be querying that data set at one time, or maybe like say n number of times in a given time period. This is a good way of probably attempting to preserve the anonymity of data, because every time there's a query, your database might introduce some amount of noise when they're giving back that data. It's still been proven by research, and I don't recollect the computer scientist's name, but it's been shown that for an adversary, for somebody who's attempting to attack such a dynamic interactive database, if they were to query if they were to query for a very large number of times, and despite any amount of noise that the dynamic database goes back to them with, there is still a possibility that they're able to recreate a large portion of such a data set. So really, I think the problem here is that anonymization is a standard that we cannot completely fall back upon. There are ways to achieve some level of anonymization, masking this with anonymization, but the irreversibility standard does not hold. And that's problematic because a lot of what we're calling non-personal data is really just anonymized personal data.
Thank you, Smita. Thank you. So Smita brings out the dangers of de-anonymization in case of anonymized data. Riddhi, I want to ask you, in case of de-anonymization, clearly it's a real danger. Whose liability would such de-anonymization be? Because there's so many different, the data trustees, the data banks, the data businesses, so many different actors in play. In case of de-anonymization, which is a real danger, who is liable? Because there's so many players involved in this.
That's an interesting point that you've raised, actually, Vipro. Because with regards to anonymization, first I would like to build on what Anubhuti had actually spoken about. So with regards to anonymization, it's very clear, and the report itself admits that it's very easy to re-identify the data at the originator of the data, the origination of the data. And so in that sense, legally speaking, there's a problem of employing certain legal tests to characterize anonymized data as non-personal data. And well, this aspect of characterizing anonymized data as non-personal data, this has to be done by the Data Protection Authority, because it's required to lay down the standards for what actually constitutes de-anonymized data. But we also need to understand that this is problematic, since framing such a standard will also be difficult, and this will require constant revision. And this actually this compounds the problem, because as we know, generally speaking, there is a general lack of capacity in India, and there are a lot of uncertainties in the Indian regulatory system, and it might not be able to hold, it might not be able to cope up with such a level of tech dynamism. But on the other hand, to answer your question about who would be liable in case there is de-anonymization of a data set, well, that is something that the report actually does not dwell much upon. So in that sense, the report has it has attempted to assuage the concerns with respect to anonymization, but in practice, because there is a lot of ambiguity within the report, so that's why it's going to be very difficult to implement these, because there are these elements there that might also lead to contradictory interpretations by different regulatory authorities when they are actually trying to determine who has to be liable for the de-anonymization.
Right. Thank you, Rithi. So anonymization, de-anonymization, this of course is one problem that might be faced by regulators. The other problem is, of course, segregation of personal data and non-personal data. We know a lot of big data businesses, so to say, handle personal as well as non-personal data, and which may not be necessarily segregated. So in line with this, Neha, could you tell us maybe how non-personal data and provisions of the PDP bill, their chances of them overlapping, and how difficult segregation of personal and non-personal data would be?
Oh, sure. Thanks so much, Deepro. It's lovely to be here with talking about non-personal data, and thanks to ThePrint as well for setting this up and for having me. I think you're absolutely right, and I do think that the report also recognizes the problem with mixed data sets. Essentially, when you have personal information and non-personal information or data being a part of that of the same data set. The difficulty is that the minute you talk about any information relating that is capable of identifying an individual or capable of relating back to an individual, you, me, Anubhuti, any of us, it becomes personal information or personally identifiable information, which then goes on to attract the personal data protection bill, which India is hopefully in the process of finalizing sometime soon. Now, that's one part of the problem, and the other part of the problem therefore then is how are you going to realistically separate what information is personal and what information is non-personal. And I don't think if you talk to any business, right, whether it's big or small, they'll be able to tell you whether or not this is, I don't think anybody will say that this is either an easy exercise to do, or even if it's an easy exercise to do, whether this is something that they even think about doing constantly, right? Because when I am a business and I am collecting information from a whole range of different sources, including the fact that there are users who are interacting with my platform or with my business, it makes commercial sense for me to have this data be as identifiable as possible, because this is the basis on which I've constructed my entire sort of business model. Yes, there might be some use cases where anonymized data makes more sense, but again, anonymization itself is a spectrum. Just building on the point that Anubhuti was also making earlier, I don't think there is such a thing as a perfect standard to achieve anonymized data. It's always going to be a spectrum, and you're going to have a little bit of a tussle here between multiple, between the two entities, between me, the individual, and the business who's collecting my information, in terms of what level of anonymization I might want this data to be. Obviously, from a privacy first standpoint, again, there are folks from civil society here who might speak to this better than I would, but it might be in the interest of the individual to say, hey, you know what, keep it as anonymized as possible, because that's in the interest of my privacy. But when you look at sort of competing business interests, or forget innovation and building new business models, even from a delivery of service standpoint, the very reason for which you came to me or came to my platform, it makes sense for me to keep it, for me to have identifiers that are associated with this information that I have of you. Then what you're asking me then, when you're saying you need to anonymize data and you need to share anonymized or aggregated data sets, what you're in effect asking me to do is process that information, have some kind of value add, perform some kind of function to take away those personal identifiers, and then make it fit to convert it into a form that is fit for sharing with the world at large, or with somebody who might query this database, so on and so forth. In a sense, what you're telling me is that you need to perform some kind of a value add function, even though you're taking away some attributes of that data set, which then takes you into territory of, oh, but well, this is actually private non-personal data as the in the categorization of the report that this committee has put out. And then, you get into questions of intellectual property protection as well. So it's not an easy exercise at all. On the personal data protection front, I mean, wherever there are personally identifiable attributes, you have the risk of attracting, in any case, the personal data protection law. And on the other hand, you're saying, well, I actually want you to do something in addition to the information that you have. But I should be compensated for that kind of an effort, is what a lot of businesses would then argue.
Right. So you're essentially saying that it might be a forced value addition that the companies need to do on their data just to be sharing it, because it's not segregated in its source, right? Smita, going ahead with what Neha said, wouldn't this sort of a confusion between personal, non-personal data and the difficult to segregate bring in regulatory difficulties? And because an NPD authority has been suggested, there's already a data protection authority that's provided for in the PDP bill. Wouldn't this sort of a situation create some regulatory confusion?
I think definitely, Deepro. And I think, Riddhi alluded to it a little bit as well in terms of the question of regulatory capacity. And I think there's multiple issues there, right? So one is the conflict between different regulators, because you're talking about having this, we don't have a personal data protection authority yet. That bill is still to pass. And once we imagine that there will be an authority there, we're talking about a completely brand new non-personal data authority. And a lot of the questions that the governance of non-personal data seeks to answer are actually, a lot of people have suggested that they are better situated in a discussion on intellectual property laws or on competition laws, because one of the main reasons we're having this discussion at all is that there's this sense that a lot of larger foreign or multinational corporations are kind of controlling the market in, so to speak, in India, right? So there's several regulators, not just the personal data protection authority and the non-personal data authority. And there's always, I mean, we have a history of, if you look into even case laws and things like that, if you look at it from a legal perspective as well, but also more of a general, political perspective as well. There's a history of some sort of conflict or some sort of tension between different regulators that we have seen in the country. And even with the Personal Data Protection Authority, it's been a question in terms of how you would have such a powerful regulator to kind of come in out of nowhere and establish and set up and work with other regulators, right? So this kind of just adds complications to that existing problem there as well if you have a new authority. But I think the other question in terms of the report does propose a new authority, but I think a lot of people have kind of suggested that we need to step back and see if we really need a new authority, given that most of the issues that we are discussing in this report or in this context are really issues that could be dealt with by a number of different authorities. It's maybe there is, I would agree that there is no one authority that's a regulator that's able to address these issues, but there are several different regulators that should be addressing smaller parts of the issues that are raised here. And I think, we have to think about it from the perspective of whether we need something brand new at all, whether we need brand new regulation or whether there is existing regulation or regulatory powers that kind of account for this, but also think about it from a perspective of regulatory capacity. If we're talking about setting up a new regulation, if we have new regulation and then we're talking about setting up a new regulatory authority, how long is that going to take? Are we really, how have we planned for it? Is there timeline? Is there capacity there? What about training? If you're talking about anonymization standards, if you're talking about then checks on anonymization, checks on what companies are doing, how do you train the regulators? How do you make sure that they know technically what to do? How do you, there's a lot of questions of capacity as well that this report raises, suggestions in this report raise. So I think there is enough to suggest that we need to step back and think about whether this is the right way to move at all. And if this is the way we're moving, then I think there are several questions that need to be answered before we can really concretely implement anything that's recommended in this report.
One of those questions, I'm sure, would be the IP implications of data sharing. That's the structure that has currently been suggested. The IP implications, I think, would be major. Neha, given that it's your core area of work, would you like to tell us a little bit about the IP implications of data sharing as suggested?
Oh, sure. I think there are two aspects to this that we're seeing emerge across a lot of the conversations that we're having with businesses as well. Concerns are on two levels. One is the copyright issue, and the second is the confidential information or trade secrets issue. The copyright aspect is data sets or databases under Indian copyright law are recognized as what is known in the law as a literary work, which means that it's capable of being protected under copyright law. There is, however, a standard that the Indian law requires, which is that you need to have some kind of creativity or some kind of originality in the data set that you have created. And provided you meet this standard, then your data set enjoys the protection of copyright law. Now, there are many arguments that have been made around, well, companies do invest time, effort, and money in creating this information. There are a whole range of different processes that you put the data to before it reaches a point where a data set is created. Anonymization, like we were talking about earlier, anonymization is in itself a process, and arguably all of these things, when you look at the creation of a data set in the context where all of these different things are taking place, it would meet that standard of originality that Indian copyright law requires, and therefore your data sets would be would be sort of deserving of protection. So therefore, any kind of forced or mandatory sharing of my information or of the data sets in which this, or of the databases in which this information is residing, will attract IP implications and is potentially an infringement of the copyright that I hold over this data set that I have created in the form that it exists. Now, confidential information or trade secret protection extends to beyond the form in which your data is residing, which is the database, and arguably protects the underlying data and the underlying data in and of itself, right? So you have IP protections that are operating on two levels, and both of these form a part of the TRIPS framework, which is a part of the World Trade Organization setup. And India has, we have commitments at the international level that prevent us from from coming up with frameworks that don't recognize and respect both a business's rights in both copyright as well as the trade secret / confidential information domain. You also have under this primarily comes from UK law, but you also have some recognition that comes through in Indian law for how companies are allowed, for what kind of for what kind of protection to confidential information extends even to information that's sort of publicly available, right? So if I can take if I can take a little bit of if I can take an example, supposing I have I'm company A, and I have created a database on the basis of information that is publicly available. I've invested time, effort, and money in creating this data set, in creating this data set, and this data set is valuable to me. It's important to my business. And now let's say Smita is company B. She comes and she steals this this database, she steals this data set, and she wants to now use it, for whatever benefit, for whatever benefits her, maybe to launch a competing product, or maybe for another, for another purpose. The court in this case will not allow Smita to benefit from such sharing, even though you may argue, well, that information was publicly available in any case. So is there even some IP angle that's attached to it? When you think about the confidential information domain, the court calls something like this the springboard doctrine, and says Smita can't use this as a springboard to for her own benefit. And you'll typically therefore see remedies that come in from courts that say, where the court will grant an injunction or will prevent Smita from using this, say, for 1 or 2 years. So recognizing that the obligation to of confidentiality extends to to the underlying data set itself, and it's valuable, recognizing the fact that I have invested time, effort, and money, which is also what sort of makes it valuable. And if you talk about mandatory data sharing, again, you're sort of just turning this on its head completely, and you're going to have to revisit a lot of these first principles that have evolved over the years.
Thank you so much, Neha. That was a very cogent explanation of the IP process involved. Moving on, the categorization of non-public data has also been done by this committee. They suggest that non-personal data should be categorized into public, private, and community data. Public is, of course, any data, non-personal data that is gathered by the government agencies. Community data, community is defined as a group of people having same interests in line with their economic and social interactions. And private data is, private non-personal data has been defined to be any non-personal data which is derived from an asset or a process which is owned by a private person or organization. Now, these definitions bring about certain overlap, at least in my mind. For example, in community non-personal data, the example given in the report is the data handled by ride-sharing apps like Uber, Ola. This could also fall under private non-personal data, at least in my mind. Anubhuti, could you take us through these categorizations and how they're going to play out, maybe?
I think after having multiple rounds of readings of this report, none of us have been able to make sense of how these categories would practically be implemented. And I feel like that's something, that's one of the first principles or the fundamental principles this report should definitely get clarity on, because if you're looking to build an entire ecosystem around this, and if you're looking to make entities share their data mandatorily, if you have different kinds of access controls, different types of protocols for data sharing for different entities, different types of mandates, then I think this is something that needs to be figured out in the report immediately. So I think your example was also the one that I actually had, Vipro. So if I had to just quickly go over these categories, public NPD or public non-personal data is the data that's been collected by government or any of its agencies. So, and then has been anonymized, of course. So for instance, land records, public health records, census data, vehicle data from RTOs, all of this would be your public non-personal data. then I jump to private non-personal data, which is data that's either been collected or produced by entities or individuals which are not the government or agencies of the state. And while in the report, they've also they've kind of used the private NPD definition to crowd in inferred data or data that's kind of being acted upon by algorithms or proprietary processing. Private NPD largely remains to be data that's housed within private entities, and then what they do with that data within their ecosystems, within their own companies, is their own matter. And then there is this new interesting category of community non-personal data, which is data that pertains to groups of individuals with a common interest and purpose. And within this community data, it's not just human community data. For instance, it's not just data about a population that lives in Andheri or about a particular about people with a particular health condition. But it would, if it were a geographical area, it also includes non-personal aspects such as, I don't know, like crop yield or soil quality of that particular region. So that would also be community data. Now you're right. The problem here is that they're not watertight at all. In fact, a lot of them seem to overlap. It's unclear where private data would be community data, where community data would be private data. And a lot of times it might be complicated where data might be collected in collaboration. So I think an interesting example is toll collection or the passing of cars through highways or flyovers that have been made in a public-private partnership. I mean, that's just one of a very, like an oversimplistic example. So I think the categories are definitely not watertight, and they definitely need some kind of clarification. This is probably not a very good one, mainly because it would just create a lot of conflict of interest, even where you had to identify which entity or which representative would be representing any of these data. I think a classic one that we've seen come across a lot is with respect to community non-personal data and the whole concept of data trustees, where they've said that in order to let communities exercise their data rights, because as an individual they can't, we'd pick out an appropriate and the most representative individual or organization that would represent the interests of such a community. In India, as we know, community, first of all, community as a concept anywhere can be complex, especially given by this report, because they're not just saying it's a recognized community, but it's just really a group of individuals with a common interest and purpose, which is quite wide. So here, even though they've said that, even though the report said that it would come out with a set of legislations to identify what a good data trustee is, I do feel like there might be a lot of internal conflicts just within the communities. There is a lot of internal dynamics within the communities. There is a lot of risk for underrepresentation or misrepresentation within the communities themselves, where there might be subgroups which have already been in a disadvantaged position. And then a data trustee which is not correctly identified, or which is not appropriate, or which does not have its incentives aligned with all the subgroups of a given community. I think that could be very problematic. The second, with respect to community non-personal data, would also be that when we're playing with large aggregated data sets, a lot of time algorithmic processing might find out groups just based on random correlation. So maybe it might just be a group of people who like to go to a particular shop to buy their grocery. And here there is no cognizance of that group, that they might be clustered that way, and therefore there might be no data trustee, and therefore there is a risk of such a group, when targeted or if targeted, being able to exercise their data rights. So I think I'd conclude by saying that I think a fundamental order of business is to get these categories right.
Thanks. Another concept that this report brings about, and it's directly related to community data, is community harm and collective privacy. The Sri Krishna committee spoke about this concept of collective privacy and how a community can be harmed if the collective privacy is somehow broken. In this regard, Riddhi, could you tell us a little about the concept of collective privacy and how the report is trying to address it?
Right, sure. So regarding collective privacy, so far all the laws and the data protection regimes have mostly focused on individual agency and the rights that were provided over information. The rights were provided as long as it related to an identifiable individual, right? But since now privacy has been understood as a fundamental right by the Supreme Court, especially in the Puttaswamy judgment, that allows one control over the context and the elements of identity. Therefore, from there, it emanates that it's bound to have a collective dimension as well. And the report does mention possibilities of collective harm resulting from inappropriate handling and exposure of this kind of data. So the recognition of group privacy is a new and definitely a welcome step because it brings the consideration of group agency to the forefront of this NPD debate. But I also think that somewhere the report falls short of defining the concept or of outlining the contours of what is it that such a group agency entails. All the while it justifies regulatory measures on the grounds of protecting collective interests, but it does not define that what is it that makes the conversation um, around it more concrete. So then there's also this unexplored dimension of creation of legal rights over data of virtual online on over the data of virtual communities. So I think all in all, although they have touched upon it, but the conversation around collective privacy in the NPD report as it stands presently, it's I would say it's high on rhetoric, but it's vague on details.
Agreed, agreed. Thanks for that. So we'll move on to our last question, I think, in our discussion, then we can move on to the audience questions. One of the questions that I had in mind was that there are so many different types of data handlers, data businesses, right? From your cab aggregators to your e-commerce companies. Now, all of them are holding data in different forms and formats. So in this regard, do you think it's possible to have one standard of non-personal data sharing for all industries and then force them to share it? Smita, maybe you can take that.
Sure, Deepro. I mean, I can probably speak more to this, just having the idea of common standard, and maybe others can speak a little bit more about the kinds of different data that the different kinds of businesses will have. But just in terms of this common standard, I think that's one of the like one of the issues with the way the report has approached this concept in the sense that we're talking about one report and then one regulation that will govern all non-personal data. And non-personal data is defined also very vaguely and broadly, as we discussed earlier, right? And the idea is also that there are specific reasons for mandating or requiring data sharing under this report or under the regulation that we're going to see. And this involves some sort of a public interest purpose or even from an economic perspective, they're talking about sharing data with private companies for in the interest of the Indian economy, in the interest of growing innovation and growing the Indian economy. The other reasons are sharing data with the government, saying that either there's a public interest purpose in terms of policy making or evidence-based policy making or delivery of services and benefits by the government. And the other reason for sharing data with the government is going to be some sort of security or national security or law enforcement purpose, right? So you have all of these different very, very wide buckets of purposes for data sharing as well. And then you have this very broad idea of like all non-personal data being shared or like a large amount of non-personal data being shared for these purposes. I think that it's the report does not go into enough detail, and the regulation probably will not be able to go into enough detail either to kind of really address what this means and how it's at best guidance on how to do this, but it's not going to be able to actually undertake this process, right? So you need to identify specific purposes, say that there is an issue in a particular city, or like there's a law enforcement issue in a particular area, or if there's say a traffic management issue in a particular city or something like that, you need to be able to identify a specific purpose, say that, okay, based on this problem that we have, we are going to, we need this level of data, and these are the companies that are likely to have this data, and then ask for data sharing, and then use that data for whatever purpose you had identified to begin with. But here we're kind of just saying that we just assume that all of this data will be beneficial in some way or the other for these three very wide categories. So I think it's going to be hard to see how you can have a common standard in that sense from a legal or regulatory perspective as well, right? In terms of justifying this kind of ask that you have, especially more so in the context where there's a potential for privacy harm, whether it's collective privacy or whether it's individual privacy in this context of anonymized data and potential for de-anonymization or re-identification as well. I think that's from the more regulatory perspective, at least. That's the answer that I would have on this question.
Thank you, Smita. Right. I think we'll move on to the audience questions that have been asked on the YouTube chat now. Let me find a good question. All right. So the first question that I can see is, has any other country made a regulation around non-personal data sharing? Is there any precedent for what this committee has proposed? Interesting question. Who would want to take the question? Anyone? Neha, maybe you could take it.
Sure. Look, I think the idea that data needs to be opened up and data needs to be shared, again, I don't think that objective it's certainly not new. You have various countries around the world that are thinking through what data sharing models, etc., should look like. I think the key difference, though, and particularly you will see a lot of this conversation coming in out of the European Union as well, and a few East Asian countries. I think Japan and Singapore have done some thinking around what data sharing models, etc., should look like. Except, I think the key difference is that all of these frameworks that you currently have in play speak about voluntary data sharing, speak about designing architectures, whatever they may be, right? Whatever the underlying arrangement be, whether it should be contractual, whether it should be done through a data marketplace, whether it should be done through a data trust. Underlying all of this is the fact that, hey, you know what? Data sharing is important, but let's look at ways in which we can make it voluntary, where we can have you either through a contractual arrangement, then you leave it to both parties to figure out what the terms of that sharing will be, or what kind of sort of how to even ascribe value to data, so on and so forth. Then you have some others that are thinking about, like, there are some organizations already who do have data marketplaces where a lot of some of the larger tech companies in the world have some of these models, etc., in place. So it's definitely not a new idea. There is thinking that's been happening in multiple countries around the world. But I don't think the model that the NPD committee has placed before us, I don't think I've seen a parallel anywhere else in the world. But I know that Anubhuti and Smita particularly also, and I know the folks at the NIPFP also have been looking into this. So I don't know if any of you ladies want to add something else.
Yeah, I'm happy to actually. As Neha said, there's obviously not exactly the same model that we've seen from any of the global frameworks that we've been reviewing for the purposes of understanding what non-personal data is. And but I think a lot of this thinking comes from European jurisdictions. I think, if there's any reading that you'll be interested in, I think the guidance on the regulation on a framework for the free flow of non-personal data in the European Union, this was a 2019 report. I think this one has been quite crucial in understanding just the taxonomy of non-personal data. So I think a lot of the human and the non-human aspect of non-personal data comes from here. Then I think a second good resource, and unfortunately, I don't remember the exact name, but it is an OECD happens to have a lot of work on data sharing and how data sharing frameworks can be imagined. And they also do have a lot of work on pricing of data, which seems to be, which is one of the presumptions of this report, that data is priceable and therefore you can build a marketplace around it. So to say there is, and of course, apart from these regulatory documents, there are a lot of frameworks already in place for data sharing. But again, as Neha said, a lot they're voluntary or they're contractual in that, say, a lot of entities in a particular area would come together. So say NGOs, companies, government organizations might come together and build data exchanges where they want to exchange data, non-personal data or data for good governance. But something like what's been proposed with the draft framework of non-personal data has, I mean, we've not seen it.
Yeah. And definitely, I think even on the objectives front, some tensions with some of these underlying frameworks, like Anubhuti was talking about the OECD, and I think OECD, I forget what report that is, or what report this is, but there's, I think they've explicitly called out somewhere the harms of mandatory or sort of forced data sharing, you know, sort of repercussions for disincentivizing innovation, so on and so forth. So the very objectives that you're claiming to sort of that you want to achieve here, I think a little bit of the solution that you have put forward for it is something that's come under criticism internationally as well.
Yeah, absolutely. Well, but on the positive front, we are on the forefront of very progressive legislation, hopefully. Right. Moving on, second question from the audience is, what is the distinction between raw and processed data? Since the usage of any data set depends on the way in which it is collected, it can be argued that all data is processed data in any way. Fair point. Fair point. Anyone wants to take the distinction between raw and processed data? How does the committee go about defining it? Smita, you can take it.
Sure. I think, I think the person who posed the question does indeed have a fair point, in the sense that I think the report suggests that data that hasn't really been worked upon or hasn't, there's been no categorization of that data set, or no attributes added to the data set or anything like that. That's presumed to be a raw data set. And they kind of assume also that that's easier to, or it's easier to ask for that to be shared, so to speak. Whereas if you have a processed data set, that means that the business in question has kind of put in significant amount of work there, which means that it's of more value to them. And that's when just the level of sharing becomes a little more, there's a little more context there in terms of whether you want to ask them to share, and compensation and all of these kind of issues, I think, would come in then. That's kind of the path that the report takes. But indeed, I think it has been pointed out that, when you're talking about raw data, it's all data that has been collected by the company for a particular purpose. I think Neha also mentioned earlier that, it's either their business model, or it's for the delivery of their service, or whatever reason it is that they are using this data for. It's inherent that that collection of data, or that building of that data set itself has been done with some purpose, which means that there's no completely raw data set in that sense of it not having any purpose there, right? There's some sort of attribute that's there. That's why there's a data set to begin with. And so I think this is not something I think that the report has addressed very well, or has not gone into much detail. And I think that's a question that will come up as we go forward.
I agree. Thank you. Right. The next question is, will non-personal data regulation apply to data processors? Are they allowed to read the data that they store? How will they differentiate between personal data and non-personal data? That's a lot of things packed into a question. But yeah, who wants to take that? Any volunteer?
I mean, I feel like we'll have to take it in parts, but I'm happy to take the first crack. I think, so data processors are, and please correct me if I'm wrong, but data processors are entities that enter into a contractual agreement with the data fiduciary as per the Personal Data Protection Bill. in order to where they want to kind of outsource any of the processing activity that the data fiduciary themselves have collected. And as per such a contract, a data processor would be held to the same standard as that of a data fiduciary. So in such a case, I think it's, I feel like we'll have to just kind of break it down. But with respect to the application of this draft framework or this proposed framework of non-personal data onto a data processor, I feel like, and I think there are lawyers on the call, so I think they're much better placed to respond to this. But I feel like, I think any kind of regulation that falls on the data fiduciary would automatically relay onto the data processor as well, or at least the data fiduciary would hold them to the same level of standard. So if a data processor were looking at data, and if it were the data processor that was outsourced to anonymize data, then I feel like they might get categorized as a data custodian within the NPD framework. But I mean, I'm happy for the lawyers to kind of, answer this because I'm not one.
Can I come in here, Deepro? I think this has actually been something that a lot of data processors have been rather perturbed by, because like, I think the fundamental principle is that I, as a data processor, don't exercise any control or have zero decision-making power when it comes to data. I don't very often, if I'm let's say a cloud platform, I don't have visibility over, I mean, I'm just giving you infrastructure and I'm allowing you the space and the tools to play around with the data, to store it and to perform any kind of analytics that you want to perform on it. But I'm not the person who's making any kind of, decisions, or I don't have the visibility over some of the processing activities that you're doing with the information, with the data. Consequently, you can't extend the same obligations onto a data processor as you would to a data controller, simply because it's just practically not possible for me to do so, number one. Number two, more importantly, from a legal sort of standpoint, right, like the distinction between controllers and processors exists or is underpinned by the fact that you want to hold responsible the person who actually has the decision-making authority, which in this case, which in the case of personal information as well as non-personal information will be a data controller. Now, to Anubhuti's point, whether or not there will be obligations that flow downstream, yeah, we do see that happen contractually. But again, those are limited to the obligations that can reasonably be passed on to a data processor. Typically, in cases of, say, data breaches, for example, you might have a contractual arrangement where both parties are going to be responsible based on whose responsibility it was or whose fault it was, right? If there was a security lapse at my end as a data processor, then sure, you can have like a contractual obligation. You can contractually and even statutorily, for that matter, have a claim against me. But in scenarios where it's just simply not possible, you can't create a legal obligation where it's just not, how are you going to, what is the underlying rationale and the basis of which you're creating that legal obligation? But I mean, I don't think the report itself makes this distinction. Most of the examples that they do give of non-personal data that they talk about, whether it's e-commerce, whether it's telecom, and there's a whole bunch of others, you will notice fall primarily under the B2C bucket. There's no, I mean, like a business to business sort of scenario, which is where your data processors come in, hasn't really, I don't think the committee has given too much thought to it or even spoken about excluding it altogether. That's, yeah.
Great, makes sense. Moving on to our next question, I'll just move on since I think the answers covered all three parts more or less, and move on to the next question. In case of mixed data sets, will the companies be required to segregate their data sets into personal and non-personal? I think we did discuss this. How execution heavy is this? Can there be cases where data sets can't be separated? Maybe the third part, the first two parts, I think we have already discussed, but maybe the third part, could one of you answer whether there may be data sets that cannot be separated, and how would this be dealt with? Riddhi, maybe.
Right, sure. So That's actually a really interesting question, because if you look at the report, there are a multitude of classifications that the report goes into. So it starts off by classifying data into community non-personal data, private non-personal data, public non-personal data. And then there's another layer of non-personal data classification, which is critical non-personal data, sensitive, and general. So after a point of time, if you look at it, because there are bound to be overlaps across these categories, and the report is not really clear around how will these overlaps be dealt with. So, and the reason that there are overlaps is because there are so many classifications that after a point of time they stop being mutually exclusive. So, so from that, I think of course, it's going to be very difficult based on the definitions that have been laid out, based on the guidelines that have been laid out in the report. It's going to be very difficult to classify data. Another good example of this would be the case of community non-personal data. So like Anubhuti had mentioned, we've gone over this. So the definition itself is very wide in its ambit. So there is a possibility that there might be multiple communities that one particular data set relates to, right? So in those cases, of course, it's going to be very challenging to come up with who the data trustee has to be, who will take the decision with respect to, and what happens in case there are conflicts between the interests of the different different communities that the data relates to. So I think those are the classifications that that the report actually it it creates way too many categorizations, which essentially takes away from clarity of these classifications, I would say.
Right, I agree. The classifications are definitely a little confusing. Hopefully, we'll have clarity once the actual legislation comes out. Right.
If I can just add there, Deepro. I think another thing, just to add on to what Riddhi put so well, I think another thing to keep in mind is the way personal data is defined under the Personal Data Protection Bill, right? So because non-personal data is sort of a negative definition where you're saying that it's anything that's not personal data. And personal data includes anything that's personally identifiable. It's not just, specifically named or an image of you or something like that. Anything that could lead to identifying you is considered personal data. And it also the bill also refers to the idea of inferred data. So they're talking about, when say a company or a data fiduciary is building a profile or something like that, where they're inferring data based on the data that they have on you, and they're storing that as well, right? And I think when you're talking about data set, the non-personal data sets, I think there's a lot of potential for overlap when it comes to especially things like the info data, because you might have a data set that says that everybody between the age of 20 and 30 likes, there's a data set of all people between the age of 20 and 30 who like a certain kind of TV show or a movie or whatever it is, right? And for the individual, if you're talking about it from the perspective of personal data, that could be inferred data about them. So there's definitely a lot of potential for overlap there, and it's also going to be difficult to kind of distinguish between personal and non-personal data in that context as well.
Our next question is actually closely related to what we were just talking about. So the person asks, should the Personal Data Protection Bill at all refer to non-personal data, or should they be completely exclusive of each other as they are at odds with each other? At odds with each other might be a bit of a stretch, but what is your opinion? Neha, maybe you want to.
Yeah, sure. Look, my personal view, and maybe everybody else on the panel will might have a different view, but yeah, my personal view is that I don't think the Personal Data Protection Bill should be the place where you regulate non-personal data. Obviously, you need to, like the point that Smita was making earlier, you need to have a negative definition. So to that extent, you need to exclude it, because you need to define what is the universe of personal information. And then, flowing from there, you will say, which the bill does in any case, that anonymized information is not personal information. So to that extent, to give businesses certainty, clarity, just even from a regulatory, principled based regulation sort of standpoint, I would restrict a Personal Data Protection Bill to that extent. I mean, even the GDPR, for example, which our bill draws fairly heavily from, doesn't get into the business of regulating non-personal data, because it's a whole other paradigm altogether. So yeah, that's where I stand. So any references that the bill has in terms of sharing data with the government, for example, for for public policy purposes, or decision making purposes, so on and so forth, I would just delete from a personal data protection law.
Fair enough. Smita, Riddhi, Anubhuti, would you have a different opinion from Neha's?
No, actually, absolutely the same. That uh, the bill that's dealing with the personal data, I think for it to have a section on non-personal data for whatever reason or whatever intent that might be, it's potentially not the place for it to be there. Secondly, um, throughout the talk, we've constantly kind of at the back end talked about whether or not we even need a regulation for non-personal data, and a sub point there has also been, what is non-personal data? So if non-personal data is going to remain something that's just simply not personal data and therefore cannot be, and therefore you're building a regulation for it, maybe there are better ways of doing it. And the personal data protection bill is not the place for it, and it's still in deliberation about whether this draft framework is.
Right. Okay, moving on to the next question. It's actually a very interesting question. The person asks, how do we balance the interests of an individual's privacy and that of a community? And goes on to give an example. If I share my blood sample data publicly, it exposes the genome data of my family. Can we balance it? Very interesting question. This would require some deep analysis. Who wants to take the question?
Well, I'll take a stab at it. So that's actually that's a very valid point, because if you look at the definition of non-personal data that has been proffered in the report itself, well, it talks about non-personal data the way Smita had explained, that there are three classifications that have been attributed to it. That it shouldn't be non-identifiable, it should be anonymized, or of course data that is inferred. So again, it becomes very clear. So a data set that might be non-personal from one standpoint might not be non-personal from another standpoint, right? So this is actually a really valid example of such a data set. That, so for instance, to give you another example, I would say that, for instance, IP addresses they are not non-personal to all the internet service providers, whereas to users like you and me, we don't have access to the kind of technology to decode and to de-anonymize that data. So from our context, of course, it's non-personal data. So again, the definition itself is too broad, and that's why I think it doesn't allow for that level of clarity for us to be able to answer that question from the perspective of this report.
Okay, so by what you're saying, then the anonymity will depend on the person who has access to the data and the processing power, maybe, of that person. Is that what you're saying?
Of course, it depends on the context and the access to the level of, I would say, mathematical models that actually end up decrypting that data, or not decrypting, de-anonymizing that data.
Okay. Fair enough. I think we have time to move on to just one other question. Yeah. So there are so many entities that have been proposed by the NPD committee. Do you see any issues with the way they are defined? What are potential points of confusion? There are so many that I can think of right now. But again, anyone want to take a stab at this? Anubhuti, Smita.
Yeah, sure. I think the one that we discussed during our course was that of a data trustee. I think that's a very contested one, mainly because we don't know how the legislation is going to play out and what would be the guidelines of picking up the most appropriate and the most representative data trustee to represent the interests of the community. So I think that is definitely one. A second one would be the demarcation of data businesses. So the thresholds that are going to come out, which make data, which demarcate what data businesses are, and therefore have to mandatorily share the data that they house within themselves. I think an interesting one within that is where an entity doesn't meet the threshold of becoming a data business or does not do most of its business in data, can still voluntarily enroll to become like a data custodian. So I think, and I think apart from that, there is the concept of data trust, which appears to be a whole new architecture or infrastructure that is envisioned for the storage process or sharing or storage of the data within the ecosystem. And then there is, of course, the concept of data principles, which has been borrowed from the personal data protection bill, and has been introduced here. But a data principle in the case of this draft framework is not just an individual, but it is also an entity to whom, so a company whose data might be housed within the Ministry of Commerce, or it might be whole communities which become data principles in the context of this draft framework. So I think, I'm sorry, what was the sub-question? I think it was, what are the issues with such entities?
Potential points of confusion was the gist of the question. So you can...
So I think definitely a major one is that of data trustees. How do you pick data trustees? How do they become most representative? And for where the communities are not recognized, or they are ad hoc communities that have been developed or identified by algorithmic processing, who becomes the data trustee or the data representative for such a case? Then obviously, I think the technical specifications for a data trust, I think that is something that would definitely require a deeper look. Mainly in terms of how secure it might be. Are we in a position, and do we have the capacity to build another large data infrastructure where we're already in talks of having a public credit registry, and we also want to do account aggregators? So what does a whole other data infrastructure mean, especially in this context? I think those would be my points of confusion.
I can add another point of confusion that I had to that in terms of data trustees and the NPDA itself. The report talks about mandatory sharing of data. Sometimes it says NPDA is the final authority on it, but it also says that data trustees can order mandatory sharing. So that might be a point of confusion.
Yeah, I think there's a little bit of a, if you look at it from the participation of the state standpoint, a little bit of a conflict, arguably a conflict of interest argument as well, right? Because there's one place in the report where it says, I think the example is health data, where they say that the Ministry of Health, for example, could act as the data trustee for all of the health data, either in a particular region, or, essentially the idea that the government could be the trustee of your data, again, which is not new. You've seen this idea come through drafts of the e-commerce policy, for example, where you say data is a national resource that the government will sort of hold in trust for its people. But the fact of the matter is that the government could also have an interest, and does have an interest, right? It functions as a data controller. And here, I mean, the terminology, I believe, is a data custodian. So you also have an interest in collecting that information, processing that information. And the state in India is a fairly wide and amorphous entity, including, it's everything from a public sector unit to a which will want to use information for for sort of commercial benefit, as well as you have your governmental ministries and departments which might want to use it for the delivery of services. The delivery of services also increasingly we're seeing has a platform. I don't know what the noun or the correct form of the word is, but essentially you're turning, the government itself is getting into the business of developing platforms, like we saw, for example, with Arogya Setu, right? So how can you be a trustee of the information when you also have interests in sort of using that information? From a legal standpoint also, there's a little bit of a conflict of interest, because as a trustee, it's my job to put your interests first constantly, right? So yeah. one more point of confusion.
Yeah, I'm sure we could go on with this quite some time, but I think we're out of time right now. So just to summarize our conversation today, we have discussed the definition of non-personal data and how wide it is. It is very, very wide. We've discussed how many bodies the NPT report plans to set up, and the confusion that so many of these bodies with having overlapping powers may cause. Having said that, this is one of the first attempts at regulating non-personal data worldwide. Well, it's attempts at a very progressive legislation. So we should definitely promote the move, but I hope that there'll be more details once the next version of the report or the legislation comes out. Thank you, Neha, Riddhi, Anubhuti, and Smita. It was a pleasure talking to you all.
Likewise, Deepo.
Thank you.
Thanks so much, Deepro.
Thank you.
Thanks everyone. Thanks.
Thank you to the audience also, especially the person who asked the question on the genome and the blood sample. That was really interesting. We will end it today. Just for the audience, tomorrow is part 2 of our series on non-personal data, 6:30 on the same YouTube channel. Tomorrow we'll be discussing whether data should be shared with Indian startups, how the data sharing mechanism should be, and if this will lead to a level playing field.